This antitrust story is years in the making. Back in 2011, a group of plaintiffs filed a class action lawsuit against Apple, accusing the tech company of monopolizing the market for iOS apps by not allowing users to download them from any source outside the official App Store. According to the plaintiffs, this not only reduces customer choice for iPhone and iPad users, but also leads to inflated pricing thanks, in part, to Apple taking a 30% cut of all app revenues. While the case was initially dismissed by a district court in 2013 due to mistakes made in the original complaint, a U.S. Court of Appeals gave the go-ahead for the proceedings to begin in 2017. Apple then filed a petition, writ of certiorari, to have a higher court review the case, which the U.S. Supreme Court has now agreed to take on. Brick the money. Apple, from the start, has argued that it doesn't set the prices for the apps, the developers do, and taking a 30% commission on paid apps and in-app purchases doesn't violate any U.S. antitrust laws. The premise for that argument, as explained by Wired, comes from an Illinois Brick Company versus Illinois 1977 case, which ruled that a company can't be sued for violating antitrust laws if plaintiffs don't directly purchase goods from them. As far as Apple is concerned, consumers are purchasing directly from the devs and its app store is only a platform that charges a commission to the developers, much like a mall charges rent for retail space. The plaintiffs, however, argue that the case is about Apple monopolizing app distribution and has nothing to do with the apps themselves.